Hi everybody, my name is Solène Senyarich, and with my classmate Axelle Delcuve, we are going to briefly present to you the position of French law regarding digital content. We will first define what represents digital content in a broadly manner and how it is already taken into account at EU level. Then, the position of France in that respect will be explained. Eventually, this national absence of specific rules regarding digital content will be compared to Dutch and English law. According to paragraph 19 of the Preamble of Consumer Rights Directive, digital content represents data which are produced and supplied in digital form, such as computer programs, applications, games, music, videos or texts, irrespective of whether they are accessed through downloading or streaming, from a tangible medium or through any other means. There are four main types of digital content, which are music, games, software, and cloud storage.
At EU level, some instruments already partially deal with digital content, even if it is not the main concern. Hence, directives on unfair contract terms, sales of consumer goods, and e-commerce make reference to digital content in contract law. In 2011, the Consumer Rights Directive was specifically extended to digital transactions and defined and regulated some of its aspects. However, some provisions have a limited scope, and the directive lacked to provide a comprehensive regime towards digital content. That is why EU institutions published a proposal for a directive on digital content in 2015.
In France, directives were transposed without the adoption of specific regulation regarding digital content. Diverse provisions make reference to digital content, such as the Code Civil as first basis regarding contract law. The ordinance of the 10th of February 2016 introduced articles on content and form of contracts by electronic means, but still nothing exists specifically for digital content. In 2014, the Law on Consumption transposed the Consumer Rights Directive. It thus provided, for example, provisions about the obligation of information and right of withdrawal. It is mainly a regulation of e-commerce to protect consumers. Then, other areas of law deal with digital content on a case-by-case basis. Intellectual property law and forgery may thus apply, for example in the case Cour de Cassation of 2012, SARL Google France versus SA Back Films. It also happened through competition law, as for example in the case Rue du Commerce of the Cour de Cassation in 2008.
So, as Solène explained to you, under French law, the rules on consumer sales apply only to the sale of tangible goods and do not apply to intangible digital content. Moreover, France does not have any specific regulation on digital content, but only fragmented references. As opposed to France, the Netherlands and the UK both have the supply of digital content regulated. The regulations concerning the supply of digital content in these countries are very recent though. Starting with the Netherlands, we may observe that as in France, the sale of digital content on a durable medium such as a DVD or a CD is treated as an ordinary form of sales, on the assumption that the digital content is an integral part of the tangible object sold. On the contrary, and as opposed to France, the sale of digital content without a durable medium, for example downloaded from the internet or web streamed, is regulated by the amendment to the Civil Code enacted in March 2014, which made the rules on consumer sale explicitly applicable to such contracts. Indeed, according to a decision of Dutch Supreme Court from 2012, in B2B contracts, the law of sale also applies to the downloading of standard software. However, It is to be noted that as from June 2015, another amendment of the Civil Code excluded from the scope of consumer sales those contracts under which the digital content is not individualized and controlled by the consumer. So, for example, contracts for the streaming of digital content are not treated as sales contracts, but are rather treated as contracts for the provision of services. This has practical consequences for the rights and remedies of the consumer, of course. In the UK, contracts for supply of digital content were initially treated by courts as sui generis contracts, which are contracts of their own kind, to which general principles of the common law apply. Today, contracts for the supply of digital content are specifically regulated by the recently adopted Consumer Rights Act 2015, in which a chapter is devoted to digital content. This chapter applies to contracts for the supply of digital content to consumers in exchange for a price, even if that price was paid for the goods, services, and digital content. It regulates such issues as the satisfactory quality of the digital content, its fitness for a particular purpose, its conformity with any description given by the trader, consumer remedies, repair or replacements, price reduction, refund, as well as liability for damages caused by the content to the consumer's device.